All right, good morning, everybody. There's a few people still dropping in, but we'll go ahead and get started. I know that many of you have a lot of questions. As you just heard, we are recording this session and we plan on sharing it out through our Commerce Chenango YouTube page a little bit later after today's session. So if there's someone who is not able to see or you want to refer back to the information, you are able to. So thank you very much for being with us today. Also a reminder that you can drop any questions into the chat box that you have throughout the day, and I'll be monitoring that and talking to our presenter. And also there will be some time for some Q&A if you're brave enough to unmute yourself and turn on your video and you'd like to ask Angelo some questions directly. We're going to keep his presentation part of this a little more informal. As you know, everything changes pretty rapidly when it comes to vaccinations and mandates. So we'll go ahead and get started. Real quick, just want to give you a quick update from Commerce Chenango. So those of you who don't know, my name is Carrie Green. I'm the president and CEO of Commerce Chenango. We are the economic development agency for Chenango County. We also are the Chamber of Commerce. We do tourism, we have a 501c3, and we also operate as the IDA. I see some new faces on here today, so I just wanted to introduce myself and let you know a little bit about what we do here. Real quick about what's coming up in 2022, which is just a few weeks away. I can't believe it. We do have a number of programs that we're bringing back this year that we're very excited about. We're doing a combination of virtual programming and in person. We are holding our notary workshop this coming year. We will be doing that in February this year, and it will be virtual. In the past, it's been a one-day training session, but the person that does this class for us has a way to do it virtually. So we'll be offering that again, and you'll see some information on that right after the new year. We are also looking at holding some virtual workplace wellness trainings. And again, we'll send some information out about that once we have a date planned. We are bringing back our Talent Pipeline and Population Recovery Strategy Summit. This was very, very successful. We held this last April, maybe May. We held it last spring and it went very, very well. And we felt that the virtual format worked really well for this so that you can jump onto sessions you wanted to listen to, but it didn't take your whole day. So we will certainly be bringing that back again. And also, we plan on doing a little bit of a roadshow with our Commerce Chenango strategic plan. The board has been working on that with me for the last few months, and we're right in the final stages of that. Once we have a strategic plan done, which is a 3-year plan, we will be doing a number of presentations around the county, and we're also planning on hosting a virtual presentation to walk you through what that strategic plan looks like. So look for more information on that. We are having all of our signature events again this coming year. So the Economic Outlook Breakfast that's sponsored by MBT Bank. The one change for this year is that we're looking at a March date instead of February. We're hoping to hold this event in person, so more to come on that. And all of our regular events as well are coming up in the new year. Another thing I just want to plug is that Leadership Chenango, if you or anyone in your business was still looking at signing somebody up for that program, the class of 2022 will begin in the new year. Applications are due December 17th, which is the end of next week. All the information can be found on our website, commercechenango.com. If you go to the Chenango Foundation, there is a tab for Leadership Chenango. It's a 2-part application. There's also an application on there for our scholarship program that we have. So please let us know if you have any questions. That will begin, interviews will be in January for the class, and the class will kick off February of 2022. And we look forward to honoring them at their graduation at the end of 2022. So thank you so much for being here today. And we're going to get right to the meat of the discussion, vaccination mandates and what you need to know. We are very happy to have Angelo Catalano. He is a partner with Coughlin Gerhart LLP. Coughlin Gerhart is also one of our Commerce Chenango members, so we are very appreciative of their support and their investment in what we do here. A little bit about Angelo. His practice is concentrated in the areas of law and employment, litigation, and public law. He has an extensive background. He is a member of the New York State Bar Association and a member of the Labor and Employment Law section. He's part of the Broome County Bar Association and is co-chairs of the Young Lawyers section. Angelo has a pretty extensive background working for the U.S. Attorney's Office, a number of different placements he had throughout law school, and then moving now into his current role. I was taking a look at his CV. He's a presenter. He speaks. He's a published writer. A lot of accomplishments, and he knows a lot about the topic that we're talking about today. And we're very, very thankful that he was willing and able to be a part of our session today. So Angelo, I know that you're on. Do you want to go ahead and I'm going to stop my screen share right now because we're going to try to keep this a little more roundtable-like. So go ahead, and Angelo, thank you so much for being a part of today. Like I said, I'll go ahead and monitor the chat and let me know if you need anything else.
Thank you. Good morning, Carrie. Can you hear me okay? Just to make sure before you sign off.
Yeah, oh yeah, I'm not going anywhere. Yeah.
Okay. All right. Perfect. So good morning, everybody. As Carrie said, we're going to kind of have this a little bit more informal today compared to what we normally would have for a seminar or presentation. And I don't think anybody will be disappointed if I tell you that we'll probably be a little bit shorter than the hour and a half we originally were slotted for today. As Carrie said, I'm a partner at Coughlin Gerhart. I'm a co-chair of the Labor and Employment Practice Group. So we only represent employers at this office whenever we deal with anything labor and employment related. I'm required to tell you at the outset of this that anything we talk about today is not considered legal advice. These are general rules and best practices and my own thoughts on a lot of these topics. You are encouraged to reach out to your labor counsel if you have specific questions for your own situation. But I'm certainly here as a resource to try to give some ideas and some of my insight and my thoughts on these topics. So first and foremost, I apologize. There is no material, there's no PowerPoint or anything like that for you to review. And the reason for that is the same reason that I apologize. This might seem a little disjointed or a little unorganized this morning. And that's not because of a lack of preparation. It's because of a lack of actual guidance to go with today. As I'm sure most of you are aware, the guidance, the standards, the orders, every single one of them that's come out for a mandatory vaccine has been challenged in court, and the vast majority of them are still stalled in the court proceedings. So we don't know what the outcome of them are. I did another review since about 7 o'clock this morning. I've been reviewing all of the cases and all of the guidance because I knew it would change. If I would have done this and created a PowerPoint last week as I had planned originally, most of that probably would have been out of date by the time we got to this today. So that's the reason we don't have one. And that's the reason there is going to be a lot of unanswered questions. And I might pose more questions than I'm able to answer here today. So that being said, we also have several industries here today. And as you are aware, there are several different mandates. So it's difficult to organize which mandate applies to which organization. You need to be cautious and know which mandates will apply to your organization. And again, you're going to need to speak with your own HR folks or labor counsel to figure out exactly which mandates may or may not apply to you. And obviously, after we finish this conversation today, there's always the possibility that everything I told you is no longer true and no longer valid because the courts could turn around and say something different from what they've been saying all along. So rather than go through what all of the mandates are and try to compare and contrast each of the mandates and explain what each one requires, I think the better option for today is to kind of give you a general overview of what some of the mandates are so that you can be cognizant of which ones might apply to you, and then to kind of go through some of the best practices, assuming that these mandates do go forward, or if you decide to implement your own policy for mandatory vaccines, regardless if any of these federal or state mandates apply to you or not. So despite that background about the general mandates, I do want to just briefly touch and go over what the current mandates are, or some of the mandates for New York State, potential New York State employers and employees. And the first one is the one that really kicked everything off, in my opinion, was the President Biden had an address, I believe it was September 4th or September 9th, where he discussed the challenges he was going, the plan he was going to put forward to combat COVID-19 and the spread of COVID-19. One of the things he mentioned in his address was that he was going to require vaccines for employers. Well, that left a lot of us labor council scratching our head trying to figure out how that was actually going to happen. And as many of us predicted, OSHA decided that it was going to issue a mandate to enforce what President Biden said was going to be the new rule. So on November 4th, OSHA came out with its emergency temporary standard. The emergency temporary standard, or ETS as we call it, basically says that any employer with 100 or more employees is required to have vaccines for all of their employees. So all of the workforce is required to be vaccinated. Or if someone is not fully vaccinated, then the employee must be tested on a weekly basis and must wear a mask at all times when they are in the workplace. So it's either a full vaccination or testing and masking for all employees. That's the OSHA standard. The OSHA standard applied to all private and public sector employers with 100 or more employees, with the exception of states that have their own local plan that's been approved by OSHA. So that hits New York State, and that leaves a major question for any municipal employers. And I believe we have a couple of municipal employers on here today. So as you are aware, municipal employers have a state-approved plan we refer to as PESH, and PESH is basically the New York State equivalent to OSHA that only applies to public sector employees. So the question becomes, if OSHA doesn't apply, do municipal employers or public employers have to comply with the OSHA emergency temporary standard? Well, at first glance, the answer is no, that a public employer doesn't need to comply. However, the OSHA standard does say that state-approved plans, like PESH for New York, are supposed to adopt policies that are at least as strict as the OSHA mandate. As far as I'm aware, PESH has not come out with anything yet to support or to follow the OSHA standard. So municipal employers, public employers, there is still a major question mark as to what parts of the OSHA emergency temporary standard will actually apply to public employers, assuming that this emergency temporary standard actually goes forward. Because as I'm sure you're aware, regardless if you're a public employer or a private employer, this OSHA emergency temporary standard is currently on hold. It was challenged in several federal courts. Eventually, through a lottery system, the challenges went to the 6th Judicial District, which I believe was based out of Missouri. And the court there, in essence, stopped the emergency temporary standard from going forward. The court there said that it was questionable if it was enforceable or if OSHA overreached its power and its authority by mandating vaccines, and therefore the entire thing is on hold. Initially, employees were supposed to be vaccinated by December 4th. That got moved to January 4th. As of right now, it is still set as January 4th. But again, the ETS is on hold as it's being held up in the court proceedings. And eventually, it's likely going to go to the U.S. Supreme Court to decide whether or not the emergency temporary standard is actually enforceable and can actually be implemented against employers. So the takeaway there is you don't need to comply with the OSHA standard yet. We don't know if you will need to comply with the OSHA standard once the courts finish the appeal process for the emergency temporary standard. Regardless of the status of the emergency temporary standard, most employers are trying to prepare as if the standard will be effective once it makes its way through the court proceeding. I don't know which way the court will decide. The court does have a conservative majority at this point, a conservative supermajority, and conservatives, generally speaking, are more against the emergency temporary standard. So there's a hunch that the court may strike it down. However, OSHA and executive orders have extremely broad authority. So there's a likelihood that the court may say, no, this is within their authority and within their jurisdiction. I'm not going to pretend like I can guess which way the court will decide. There's all sorts of pundits that can do that for you. So at this point, we prepare as if the standard will become effective, but with the understanding that there's a good likelihood it may never become effective. I can also advise you that several of my clients are basically creating their own policies because they're so confident that it is going to go forward that they do want to just get a leg up on it and basically start the process right now. So assuming the ETS goes forward and is not completely stopped in the court system, what does it mandate? Well, as I said, it mandates that all employees must be tested. If they are, all employees must be vaccinated. If an employee is not vaccinated, then they are required to do weekly testing and wear a face mask while they're at work. Weekly testing means that they have to be tested once every 7 days. If they are not going to be in an office setting or physically at work for more than 7 days, then they are not required to submit a test for that period of time. But as soon as they return to work, they are required to provide a test, and they are required to provide a test every 7 days, if not more frequently, in addition to wearing a mask. Let me just find my spot here. I apologize. The emergency temporary standard also requires employers to provide their employees with time off in order to get vaccinated and in order to recover from any side effects of the vaccine. This really isn't that big of a hit for most New York employers because New York had mandated this a while ago. New York had only required it for 4 hours to go get the vaccine. The emergency temporary standard doesn't tell us exactly how much time we are expected to give an employee to go get vaccinated under this policy, but we are expected to give them time off to go get vaccinated. And if they have any kind of a reaction, we're required to keep them with that time off while they are out. Again, New York State already requires this. For my private sector employers, your employees are going to be covered under New York State's paid sick leave. They're going to be covered potentially under New York State's disability benefits, and they're going to be covered potentially under New York State paid family leave. For my public sector employers, they're going to be covered only under the mandate for the 4 hours or any PTO or contract provision you have regarding the side effects or the testing, or the side effects or the vaccine time off. As stated, the whole thing is still in limbo right now because it's working its way through the system. It would only be applicable to employers of 100 employees or more. However, I say that with a caveat. The standard, which is, I believe, 490 pages long, specifically says in the standard that it only applies to employers of 100 or more, because OSHA is confident that large employers have the ability and the capability much better than a smaller employer to implement this standard and to pay for individuals to have the time off to get vaccinated and to recover from it. It specifically says in the standard, and I don't have the language in front of me, but it specifically does say in the standard that it is aimed toward decreasing the number of employees to apply for the standard. So right now it's 100 employees or more. I anticipate if the standard does not get killed altogether in the court system, I anticipate that it will get dropped to 75 or 50 or more employees. Eventually, I think it'll get dropped to 25 or more employees. I think it will continue to work its way down to maybe 5 or 10 employees would be covered under the emergency temporary standard. And at that point, it would probably just be the standard, no longer the emergency temporary standard. So I say that to warn everybody that even if you're well under that 100 employee mark, you should be aware of it because it's likely going to make its way down to you if you have less than 100 employees and if the standard continues to go forward and isn't stopped altogether. The second federal mandate is the federal contractor mandate. Originally, any and all federal contractors were required to be vaccinated by December 4th. Well, actually, I believe the original date was November 4th or 15th. That has been changed numerous times. At this point, all federal contractors are required to be vaccinated by January 4th. And I say that but it actually was unclear because some of the guidance this morning was still saying January 4th. Other guidance was saying January 18th. So I'm not sure if it's actually January 18th or January 4th as of this morning, because it continues to change. I think it was a typo. I think it was originally December 18th. It got moved to January 4th. So I think it's supposed to be January 4th, but I think somewhere along the way, it got switched to January 18th instead of January 4th. The federal contractor mandate requires every contractor, subcontractor, or employee or visitor to a subcontractor or contractor of the federal government to be vaccinated. There is no exception for testing and masking like there is under the OSHA standard. The only exception would be if someone requires an accommodation for medical or religious reasons. So that's the big distinction between the federal contractor mandate and the OSHA emergency temporary standard. The OSHA standard is test or vaccine. The federal contractor is purely a vaccine mandate with no option or alternative for testing and masking for employees. This is also on hold due to legal proceedings, so this is not enforceable yet. It's been challenged. It's being held up in the court system on appeal. We are awaiting a determination on that. This one, I have more confidence that it will be enforceable after the court system hears it. I think that because the federal government can issue contracts as it sees fit, and because contracts are generally, you're allowed to contract to do whatever you want as long as it's not illegal, I have a suspicion that the courts will allow the federal contractor mandate to go forward. Again, just my thoughts. I'm sure there's a lot of pundits out there who will tell you their own opinion on it, but I do think this one has a better likelihood of succeeding than the OSHA emergency temporary standard has. The next or the final federal mandate that I'll talk about and touch on is the Department of Health and Human Services mandate. And this also applies to anyone receiving Medicare and Medicaid funds, frequently referred to as CMS funding. This mandate is extremely similar to the federal contractor mandate, and it's supposed to be effective January 4th, 2022, but this is also on hold due to court proceedings. So again, like the contractor mandate, it is in essence that it's a vaccine only mandate with exceptions for those seeking an accommodation for religious or medical reasons, but no testing and mask wearing option or alternative. It is a vaccine 100% of the way mandate. So those are the federal mandates, the big federal mandates that are out there. There's also mandates for federal employees, but we don't have to address that with this audience. So the next set, it would be the New York State mandates. New York State mandates started in August when New York required all patient-facing healthcare workers to be vaccinated with no testing alternative. This mandate was really a hot topic. There were 2 federal cases filed against it because the state originally came out with the standard on August 18th that allowed for medical accommodations as well as religious exemptions from the mandate. When the final standard came out 8 days later on August 26th of this summer, the religious exemption was removed from the final rule. That led to several challenges in federal court alleging violations of First Amendment rights in Title VII of the Civil Rights Act violations. The court out of Utica, New York, said that the New York State mandate was not enforceable and stopped it in its tracks. Meanwhile, a federal court in New York City said that the mandate was enforceable. This led to an expedited appeal to the Second Circuit Court of Appeals, which is the court that governs our area. And there, the federal court said that the mandate is enforceable. And part of their ruling for it being enforceable was that while the language of the order of the regulation did not specifically say that religious exemptions are allowed, it doesn't specifically prohibit religious exemptions. So the court, in essence, said that the mandate does allow religious accommodations and religious exemptions. So that's where the status of that one is. That was just decided back at the beginning of last month, the Second Circuit. I don't know if that's been challenged. I assume that it has been challenged to go to the Supreme Court, but I haven't heard anything further on that one. The challenge is still out there, whether or not it's actually enforceable, but it is enforceable for the time being. It wasn't temporarily stopped like it originally thought it would have been. So the New York State mandate, there's also a New York State mandate that applies to all state employees. That mandate, unlike the medical one, is more similar to the OSHA standard. The New York State mandate for state employees is that all employees must be vaccinated or tested on a weekly basis and wear a mask whenever at work if unvaccinated. New York State also had a requirement that came out over the summer regarding school employees. Excuse me. New York State also had a mandate for school employees. The mandate was for all staff of schools, which has become an issue of contention and an issue of trying to define exactly who it applies to. But regardless, New York State has required all school employees to be vaccinated or to be tested on a weekly basis, regardless if somebody is vaccinated or not. If they're in a school, they're required to wear masks at all times. So the school mandate is vaccine or test, but regardless, they are required to wear masks. So as you can see, there's different standards in New York, depending on the industry and depending on which rules govern and apply to that industry. New York State then had another medical or healthcare mandate applying to anyone working in a facility served by the Office of Mental Health or the Office of People with Developmental Disabilities. Anyone working in such a facility was required to be vaccinated without the option to test out. And finally, which hopefully doesn't apply to anybody in this chat, New York City Mayor de Blasio announced yesterday that he will be requiring all private employers to have vaccine mandates for their employees. I have not found any text for the New York City mandate yet, or how it's going to apply or who it's going to apply to. But I mentioned this to you, even though we're not in New York City, because New York City mandates for employers can be very, very vague and very broadly construed to apply to those you might not think it would apply to. For example, there are certain New York City mandates that say if you have any employees who work 40 or more hours in the year in any of the 5 boroughs of New York City, then you are considered a New York City employer. So if you have anybody doing business, doing deliveries a couple of times a year in New York City or passing through, going to conferences, anything like that, there is a chance you could be considered a New York City employer. Again, this was a press conference. I don't have any of the text of it. This is why there's no PowerPoint. This came out yesterday and we still don't know actually who it applies to. Again, I highly anticipate this is going to be challenged. I think that at the initial level, it will probably be stopped, just like every other mandate has been stopped at the initial level. When it makes its way through an appeal, there's a chance that it might be enforceable, but we will hopefully by then know exactly who this mandate actually applies to. So those are kind of the general background of the mandates that are out there. You obviously can also have some local municipalities have their own mandates, and several employers have already issued their own mandates as well. But with all of those different mandates in mind, I figured it'd be good to think of some general rules to keep in mind and some best practices when dealing with employee vaccines and mandatory vaccines or testing. So first and foremost, as I've said numerous times now, we don't know if the federal mandates will hold up. The federal mandates are all challenged right now. They are all waiting for the courts to decide if they are enforceable or not. But as I mentioned before, there is broad authority and broad discretion for OSHA and for the federal contractors. So I do think that there's at least a good likelihood that the mandates will hold up. The other thing to keep in mind is that all of these mandates came out when the Delta variant started surging over the summer. At this point, we're now dealing with the Omicron, and I'm probably butchering how you pronounce it, but we're now dealing with and hearing about the Omicron variant, which is supposedly more dangerous and more infectious than the Delta variant. So a lot of these rules and regulations were put in place to combat the Delta variant. And now if something more dangerous or more contagious is replacing Delta, I think it's more likely that a court could say this is a true emergency and we do need to have these going forward to combat the continuing changed variants and modifications and mutations of the COVID virus. I joke frequently that the virus itself seems to mutate and have all sorts of variants, and I can't keep up with the status of the law that keeps mutating and changing with all of the mutations and changes of COVID itself. So we're trying to keep up with that just as much as the doctors are trying to keep up with the changes to COVID itself. The CMS mandate, and one more aside regarding the federal mandate, one of the big issues that I do foresee is the CMS mandate and the New York State healthcare worker mandate are in direct contradiction to each other. The CMS mandate does say that religious exemptions are permitted, and it does say that it explicitly states that it preempts state law. So if federal law and state law are in contradiction, federal law 9 times out of 10 will trump the state law because of what's called the supremacy clause. The federal government is supreme to the state government when they address the same topic and issue. So the New York State mandate doesn't have the religious exemption. The CMS mandate does require the religious exemption. If the CMS mandate goes forward and is not stalled in the court system, I do expect there will be lawsuits over the New York State conflicting with the CMS mandate. Ultimately, I don't think it makes that much of a difference because the Second Circuit decision from last month did specifically say that although the New York regulation doesn't spell out a religious exemption, it does permit a religious exemption. And the example given in the Second Circuit decision from last month said that it doesn't spell out that you have to give an accommodation, but it doesn't stop it. And the example was that if a doctor or a nurse doesn't want to get vaccinated because of their sincerely held religious beliefs, the employer can permit the employee to work remotely or to do some other task that would be consistent with their job, but they might not be patient forward-facing employees for the time being. So there is a conflict, but I don't think the conflict is really that severe. I think ultimately you can comply with both without too much difficulty if they both stand the appeal. So assuming the mandates do apply, what do we do with our workers? First and foremost is going to be developing a comprehensive written policy. OSHA has a sample policy that is quite good. OSHA came out with it, expecting employers to adopt it as the model policy and to follow it because that's what they want you to have. It covers all of the issues that the OSHA mandate requires, which makes it a good policy to follow. If the OSHA standard becomes the standard and withstands challenge, then we certainly would like to follow what OSHA tells us is the best practice because you're less likely to get in trouble if you comply with exactly what OSHA told you is the model policy. So I think if you're looking for a policy, a search for the OSHA policy will be your best template to use. And again, the OSHA policy, the OSHA mandate requires a written policy. New York State also requires written policies for things like this. So you're definitely going to want to put something in writing to address vaccine status for workers. It also gives you a guide to follow so that you follow the same policies and procedures for each and every one of your employees. You don't want to address it one way with one employee and address it a different way with a different employee because that opens you up to lawsuits for disparate treatment or for treating individuals differently depending on their circumstances. So what do we do to actually get the proof of the vaccine? Well, when vaccines were first, vaccine cards and employer copies of vaccine cards were first an issue, we got to think back to, I believe it was April or May of this year, where in essence, most employers said that employees were no longer required to wear masks if they provided proof of vaccination. So when that was the standard, the general rule of thumb that we used and that we followed was that you didn't want a copy of your employee's vaccine card. The best practice that I had recommended was that you have a list of your employees, and when your employee shows HR a copy of a vaccine card, you can basically cross that person's name off, and then that person is no longer required to wear a mask. You didn't keep a copy of it, you just confirmed they actually were vaccinated, and you didn't make them wear a mask anymore. That's not going to fly anymore if the OSHA standard is enforceable. The OSHA standard has very specific rules about what you have to get for vaccine proof and what you have to maintain in your system. You're going to want the original vaccine card, and you're going to want a copy of the original vaccine card. There are rules about what to do if the employee can't find it or lost their card and can't get a copy of their card. So you do want to get a copy of the actual vaccine card, assuming that the standard goes forward. You're required to keep a copy of that in a confidential folder. You then want to keep it as if it's a medical record. Just like if an employee brought you any other medical record, it would be in a confidential folder or a file that nobody else had access to. That's exactly what you're going to do with the vaccine cards. So if it goes forward, that is definitely something you want to get. You are also supposed to get the employee's name, and you're supposed to keep a copy with the type of vaccine they received. So Moderna, Pfizer, Johnson & Johnson, the date of the vaccination, and you're supposed to get information about where they actually received the vaccine, whether it's a healthcare clinic, a pharmacy, a doctor's office. I'm not quite sure how we're supposed to keep track of that, or if we just take the employee's word for it. And I'm not even sure why OSHA is so strict about having those, unless they just want to make sure that there are no fake cards. I don't know if I have a lot of football fans out there, but Antonio Brown with the Buccaneers is famous right now for having a fake vaccine card. Maybe that's what OSHA is thinking about, is preventing fake cards. And the more information you require, the more likely it is that you get an authentic vaccine card from your employees. So if someone isn't vaccinated, then we have to look into the vaccine and the testing and masking issues. If employees are not vaccinated and they're taking the testing option, then you want to consider potentially contracting with a company to provide those tests for you. Now, this is going to be a matter of your size and your capabilities. I assume that it's probably rather expensive to have a company come in and do testing on a weekly basis for employees. If you have 3 or 4 employees that are not getting a vaccine and are refusing to get a vaccine, then you may want to just have them go get tested on their own. If you have 150 employees that are refusing to get vaccinated, you may want to consider bringing somebody in to do the testing right there at your facility so that it's a little bit easier to keep track of. That's going to come down to a matter of logistics and what works for you. The OSHA standard does recommend that if you only have, again, think back, the OSHA standard is 100 employees or more. The standard contemplates that if you only have a small handful of employees who choose the testing and masking option, if you have 4 or 5 of them, then leave them be, let them do it on their own and bring you the test results. The OSHA standard recommends that if you have 100 or 75 employees that are choosing the masking and testing option instead of the vaccine option, OSHA recommends that you institute your own policy that mandates vaccines because they think it's too dangerous to have that many employees unvaccinated. So if there is some discretion in there, you can create your own policy that is stricter, that removes the option for testing and mask wearing. And that's what OSHA recommends if you have a lot of pushback, which is kind of counterintuitive. If you have a lot of pushback and your employees don't want to comply with a federal mandate, you risk losing employees if you push too hard, obviously. Now, that's a matter of business decision, and it's a matter of your own logistics. It's not a legal issue. It's just something to consider. One of the things that OSHA did talk about in the standard, as I mentioned, is that they anticipate reducing the number of employees in order to qualify for the OSHA vaccine mandate. One of their rationale for that was that they expect employees are going to leave large employers to go to smaller employers in order to avoid the vaccine requirements. So they want to basically chase the employees to the smaller employers to get more vaccines. Again, it's one of their stated reasons and expectations of what's going to happen with the OSHA vaccine mandate. So I got a little bit off track there. I apologize. So if we go back to the idea of employees who choose the testing and masking option instead of the vaccine option, for those individuals, you are not required to pay for the test. You do not have to pay them for the test. They have to go get tested on their own, and they have to pay for the test themselves. Again, if you want to pay for it, you're able to, but you're not required to pay for the testing. The bigger issue becomes whether or not you're required to pay for the time they go to the testing site. And this is an uncharted area that there is no black and white answer to. If you have contracts in place, collective bargaining agreements, you have to review what your collective bargaining agreements say about this type of thing, about ordering someone to go get tested, if they go get tested during work hours or after work hours. You have to review those and see what happens. The general rule of thumb would be that if you have an employee who is paid it's paid minimum wage or right around minimum wage, you may want to pay them to go to the testing site so that there's no question that if it's determined they do have to get paid for testing, then you paid them enough and you're not going to be on the hook for failing to properly compensate them. If you have employees that are paid well more than minimum wage or are paid a salary basis, you're less likely to have to pay them for that time because you're already compensating them enough for that time they've potentially gone to get tested. This is, again, a gray area. The OSHA standard specifically says that you are not required to pay for the time it takes to go get tested. And then it has a footnote that says, however, contracts and local state laws and rules may require you to pay employees for testing. So the Portals Act basically says that if you have an employee that is working or that is conducting an activity in furtherance of their employment, then you are supposed to pay them for that time. There are certain types of tests that are considered working, so you are required to pay for that time. We don't know right now if the COVID testing requirements will be considered mandatory time to pay employees or not. I think it's going to depend on the industry. It's going to depend on practice. It's going to depend on how and when your employees are paid as to whether or not this actually is something you have to pay them for. It's too nuanced to get into the details of the Fair Labor Standards Act and the Portals Act. So I recommend you consult with counsel if you are trying to figure out whether or not you're going to pay employees for their time to go get tested if it's not during the normal working hours. It's very clear if it's during working hours, you have to pay them for it. If they have to get tested on their own, they likely don't have to be paid for it. But again, you're going to want to consult with counsel to make sure that you're in compliance with the Fair Labor Standards Act and the Portals Act. If someone fails or refuses to get tested, you will be required to remove them from the workplace. Under the OSHA standard, they pose a safety threat. Therefore, you have to eliminate the safety threat by removing them from the workplace. If they fail to comply and you remove them, they are not going to be paid for that time they are removed unless they're a salaried employee who still performs some work that day. So again, that's going to become a Fair Labor Standards Act issue that you may want to discuss with counsel. The issue of them being removed is not a question. If they refuse to test or they don't provide you their weekly test, you need to remove them from the workplace. OSHA also recommends, and in their sample policy, they discuss having rules regarding vaccine proof for visitors or anybody else who's not an employee who may come to your work site. Something you might want to consider. For example, our firm has posters on the doors that everyone who enters is required to wear a mask regardless of vaccine status, because it became too onerous to try to check vaccine cards, especially among the recent surges. So something to consider, whatever fits your business needs best, then you know that better than I do. But it's not a mandate, but it is a recommended best practice to create a safe and work environment for your employees, that you have some rules and requirements for visitors or customers or clients. So the last big topic that I want to address with you regarding vaccines is accommodation issues. That's the big one that everybody wants to know about for the most part. So the Americans with Disabilities Act and Title VII of the Civil Rights Act require employers to grant employees reasonable accommodations to individuals who are otherwise qualified to do the job, so long as they can do so with a reasonable accommodation. So what does that mean? It means that if an employee is subject to the vaccine requirement, and they have a legitimate medical reason why they cannot get vaccinated, then you are supposed to accommodate them by giving them a reasonable accommodation. So if you have a forward-facing healthcare worker and they cannot get vaccinated because they have some allergic reaction to the vaccine itself, you are supposed to accommodate them. That means that rather than terminate them, you might move their employment to another location of the building so they're no longer patient-facing. You may require daily screening, or maybe you do it twice a day. You monitor their temperature and do screening of how they're feeling and if they have any signs or symptoms or conditions of COVID. So you're doing other things, or another example is if you have a forward-facing patient employee who's not subject to the testing option, maybe they get the testing and masking option as an accommodation. So it's going to be fact specific. You have to analyze what the individual's job is, what their accommodation could be, so they can continue to perform the essential functions of their job in a way that's not unduly burdensome to you. That means you don't have to spend thousands of dollars to create some atmosphere for them where they can work. You just have to do something that's reasonable, which might be testing and mask wearing for an employee who's otherwise required to be vaccinated. Same thing applies with if you have your own local rule for testing and you're not following the state or federal mandate. If you simply have your own policy and an employee is unable to get vaccinated because of a health issue, then you likely have to accommodate them by allowing them to not be vaccinated, but to do testing with mask wearing. There are very, very few medical accommodation requests. I can tell you, I have not had a single request for a medical accommodation. And I assume the reason for that is that the vaccine, by and large, is safe. And by and large, there are very few people who have an allergic reaction or have a real medical reason to not get vaccinated. I know initially one of the big reasons was pregnancy, that a lot of doctors would say their client or their patient couldn't get vaccinated or shouldn't get vaccinated because of pregnancy. That's one of the only ones that we still see a decent amount of doctor's notes. And if a doctor says that the patient shouldn't get vaccinated or that they recommend they not get vaccinated, then you probably want to and need to accommodate that request. But again, the medical exemptions, with the exception of pregnancy, are quite rare. And I believe that's because very few doctors are willing to sign a note that says that somebody medically cannot be vaccinated. The more common accommodation requests that we seem to be getting are employees who claim they can't wear a mask because it impedes on their breathing or something else. They have an allergic reaction to the mask itself or something like that. The most common response to that would be an accommodation of giving them a face shield rather than a face mask. If somebody can't breathe because they have asthma or some other condition that makes it hard to breathe with a mask on, a shield doesn't impede the airflow, but it does still provide some level of protection. So that could be a reasonable accommodation for someone who says they can't wear a mask. The big one, the big ticket item would be the religious accommodation request. I have seen many, many more religious accommodation requests than I have seen for the medical accommodation request. The biggest thing to keep in mind with religious accommodations is that it has to be a sincerely held religious belief. It does not, you don't need to accommodate a political belief, a belief that they have certain legal or constitutional rights that prevent them from getting vaccinated. You don't need to accommodate somebody's belief in a conspiracy. You don't need to believe or accommodate somebody's fear of the vaccine. Those are not accommodations for religious reasons. Religious reasons are limited to religious purposes. Now, I say that, but religion is not confined to the three major religions, Christianity, Judaism, and Islam. It is not confined to those. Likewise, almost all of the religious leaders of the major religions have said that it's perfectly fine to get the vaccine. That doesn't matter. Somebody can have their own religious beliefs as long as they are sincerely held religious beliefs. They might be entitled to an accommodation. A perfect example, the Pope has said, the Pope is the head of the Catholic Church. The Pope has said it's perfectly fine, or it's good, it's an act of love to get the vaccine. There are several Catholics who disagree with the Pope, and their sincere religious belief is that it is a sin if they get a vaccine. That is a sincerely held religious belief, despite the fact that it conflicts with the leader of the religion. So you've got to be cautious with these religious exemption requests. But as I keep saying, it has to be religious. Every single one of the requests I have seen for a religious exemption has not been an actual religious exemption request. Every single employee who has submitted a request has said that their religious beliefs prevent them from getting the vaccine. So the next step is you ask them to put in writing exactly what their religious beliefs are that prevent them from getting the vaccine. Every single one I have seen. Now, there are certainly some out there that are going to be different, but every one that I have seen has included some link or some printed out page from something online that basically details what somebody's constitutional rights are, or they reference the Nuremberg Code about unauthorized experiments on individuals. They list their constitutional rights. I think I already said that. Their fear, conspiracy theories. Those are not religious beliefs. They are not entitled to any kind of an accommodation. So if somebody requests an accommodation, step one, ask them to put in writing why they cannot get tested or vaccinated, what their objection is. If they provide you a writing that has political beliefs, their belief in what their rights are, those you can say, we deny your accommodation request because your request is not a religious exemption request. It's an exemption because of your political beliefs. If they put something in writing that actually does establish that it is their religious belief, that they believe that the Bible tells them they can't get it, or they believe that the Quran tells them they can't do this. If they have that in writing, then you can do a follow-up with them. If you believe their religious belief, then you can grant them an accommodation. If you have further reason to doubt it, well, then you can sit down and actually explore it further with them. You can ask them to explain in an interview with you what their objections are, how they believe it's a violation of their religious freedom, or what their religion tells them about it. And you pay close attention. If they continuously refer to political issues when you're talking with them, well, then it's not really a religious belief. If they keep telling you about how it's an act of sin and they're going to be damned for eternity if they get the vaccine, well, then it's more likely going to be a religious issue. So these are matters that there is no one size fits all. They are very fact specific. You need to be very careful with how you address those issues with your employees. The last two issues to deal with when it comes to accommodation requests is that you need to be on alert. Somebody might not specifically say, I want a religious exemption, but if they tell you, I don't think I can get vaccinated because of my religion, that should set off bells and whistles that you follow your procedure. The next two things are probably the most important in my opinion. The first is that you need to establish your own internal policy or procedure for handling these requests. You should have somebody, an HR person, some kind of a supervisor that is the go-to person, that if somebody has a request, okay, we know this goes to Jane Doe or Bob Smith handles all of these requests. And they have their playbook of how to go about addressing these issues. The last item is that you want to document everything you do with regard to accommodation requests and anything you grant for accommodations. If you have that interview with somebody requesting a religious accommodation, you want to write down your notes and you want to document that you had that meeting and why you decided to grant or to deny the request for an accommodation. And that basically wraps up my outline, and I'm sure I've probably got a couple questions pending, and I can do my best to answer with, again, the understanding that it's not legal advice and that this stuff is changing rapidly. So who knows what's changed in the course of my last hour of talking here.
Thank you so much, Angelo. That was a really great overview, and you might need a minute, so take a sip of water. Before we open it up to everybody, we had a question that was submitted in advance, so I'll go ahead and ask that to start things off. And for everybody else, you can either, once we're done with this question, feel free to unmute yourself and go ahead and ask, or put it in the chat if you'd rather me ask the question for you. So the one question that we received was about a lot of what you were talking about had to do with OSHA and the larger over 100, which, and I understand you said you expect that number to go down. What about the private sector employer that is not technically required because it's not a health organization or a municipality, but it's a private sector employer that wants to institute a vaccine mandate for them? Again, without it being legal advice from you, one, are they able to do that? And two, what process should they use to implement such a policy?
Yes, absolutely. So employers are allowed to institute their own vaccine mandate if they choose to do so. The only real exceptions are you have to allow for accommodations like we just talked about for religious or medical exemptions. And that's really about it. The process, it's going to depend on your facility and what you are trying to accomplish specifically. I would point you to the OSHA standard model. I think that's probably going to be the best model because it's already pretty much thought of everything. So we had a lot of employers, and I'm sure you saw over the summer, there was all kinds of employers that were listed as instituting their own internal mandates. I know a lot of airlines were. I think Walmart had its own mandate. So yes, private employers can institute their own policy, their own rule if they want to. The best starting place is probably to search for the OSHA model policy. I think that's going to be a good starting point, even if it doesn't actually apply to you, because then you can also kind of cherry pick what you want to use and what you don't want to include in there.
Thank you. We had somebody submit a question in the chat. Is the issue of who pays for the testing subject to impact bargaining?
That's a good question. It probably is. Impact bargaining can touch anything that is a term and condition of employment. So I would say, yeah, probably is subject to impact bargaining. If somebody doesn't want to get, and it depends on which category we're in, of course. If it's you are unilaterally creating your own policy, then it's definitely going to be subject to bargaining. If you are required to comply with one of the other standards like OSHA or CMS, then it's no longer your option or your choice to allow the testing. It's now you are mandated to, so you bargain over what the impacts are, but that's it. You are required to comply. But yeah, sure, we'll sit down and discuss with you what the impacts are.
All right, go ahead and open it up. If anybody else would like to go ahead and unmute yourself and ask a question. We've got Angelo for a little bit here still if we have questions. So.
Hi, this is Mary Branham.
Hey, Mary.
Hi. So Angela, my question to you is, I am a small employer. I work with large companies though, such as Verizon, Comcast. And my customer isn't Verizon in one situation, but we subcontract to a company that subcontracts to Comcast. And there's Verizon put out a mandate saying everyone's got to be vaccinated on their sites. And I've got the issue that I'm a small employer, and I do know I have a few people on my staff that will not get vaccinated, which will hurt my company if that was to be mandated. How does it work for companies like a Verizon or a Comcast pushing back on you?
So it's a good question. And the truth is that they can kind of do what they want to.
Okay.
You are under contract with them. And general rule of thumb is that parties can contract for anything they want to, as long as it's not illegal. So if they want to have in their contracts that you are required to have 100% vaccinated staff in order for them to work with you, they can put that in a contract. If you already have an existing contract with them and they're trying to change it, then that might be an issue of, are they breaching your contract or not? I can tell you, I have had a client who reached out with a similar issue where their staff were going to refuse to be vaccinated. They were going to lose all of their truckers for this industry I was working with if they forced a mandate on their staff. Well, the issue became that their contract with who they were contracted with said, we're requiring 100% vaccines unless there is a reasonable accommodation granted to your employee. Well, my client chose to grant all of his employees religious accommodations. And he could then tell his contractor with a straight face that 100% of his staff was vaccinated or was not vaccinated because of a religious accommodation. And that was his solution to the issue, or the solution we came up with, because he, as the employer, because he wasn't subject to any of these other mandates, he, as the employer, has the sole authority to determine whether or not he believes someone's accommodation request is sincere. And he believed his employees had sincere religious accommodation requests.
Okay. Yeah. Well, I was even thinking about that when you were saying the part about the religious accommodation. An employer could literally do a form letter of what and say, just sign that this is what your belief is and be done with it. But
you certainly could. You could. The issue becomes if you are subject to any other mandate and you unreasonably granted accommodations that weren't real accommodation requests under OSHA, for example, then it could be an issue of not creating a safe workspace.
Right.
Or if there's obviously.
And then the other question I have, this is a two-part question, because the companies that I'm dealing with are asking, they're saying, oh, you've got to turn over the proof of the card to them, which I don't agree that they should have. I do have contracts with these companies where I've got to drug test my employees and do background checks. Now, I let them know that, yes, I have drug tested my guys, and yes, they had background checks when they were hired, but I don't provide that to them. So now they are saying they want a copy of the card. And I said, I don't think you can have it.
Yeah, that's going to be one of the hot button issues with this OSHA standard and with the other federal standards for contractors, is that they are on the hook if they have somebody on their site that's not actually vaccinated and didn't comply with the standards that they are subject to. So we're seeing more and more of that. I'm of the position that you should not turn that information over. That's a confidential employee record. Now, the only issue would be potentially getting a waiver from your employees where they sign off and say they approve you to turn that over to your contractor so that they can continue to work and have a job to do. But by and large, I don't think you want to turn over employee records to an outside entity without employee approval.
Okay, great. Thank you very much.
Absolutely.
Good questions, Mary. Thanks. Anyone else? Okay. Just looking through the notes I had to see if there was anything else that came up.
We came closer to filling the full time than I had anticipated.
We did, yeah. Another second questions. Okay, well, as a reminder, this has been recorded and we'll be sharing it out via our YouTube page. And I just once again want to thank Angelo for such a great and thorough discussion. A lot of really great information. And if anything else pops up, please let us know. I know he's always willing to be a part of what we have here in terms of programming. So real quick, just here's our contact information for Commerce Chenango, and please reach out if there's anything that we can do to help you. And I guess we'll close it with that. Thank you so much, and we really appreciate it. And thanks again to Angelo and Coughlin and Gerhart.
Thank you very much. We appreciate it.